Hello, this is Erica Norton, and I'm the founder of Perfect Legal Video. I am very excited to have with us today Attorney Nicole Reeves Lavallee. She owns a family and real estate law firm out of the Worcester area, and she's here every week to answer all sorts of questions that I feel end up saving people tens of thousands of dollars in the long run if you are having these issues. Let's talk today about a little bit more about death. Our favorite topic. Welcome to the show today, Nicole.
It's such a glorious topic, isn't it?
Oh, it is, and on such a beautiful Friday. So today we're going to be talking about, um, when you go through a divorce and you have child support, it's pretty common to have a life insurance policy as part of the divorce agreement for whoever is paying the child support, just in case they pass away, just to make sure that the children are still taken care of. I mean, is that fairly common, or is that just something that you did for me?
That's required basically because then people can't pay child support, and your obligation is still to pay child support so long as they're not emancipated. And if you're the custodial parent, guess what? The other party becomes the custodial parent, which means you still need to pay child support.
Well, I mean, so that's interesting. Let's say there's a scenario that I heard about where somebody was divorced and they had two children, and the father who was paying the child support passed away at a very young age, a little over 50. And so the children were still in need of support. And there was supposed to be a pretty good life insurance policy to help cover the rest of the child support if anything like that happened. And guess what happened?
Policy lapsed.
That's right. The policy lapsed and there was no policy. And so, where do you go from there?
Well, hopefully that person died with some assets because obviously the life insurance policy, a $200,000 policy was supposed to be in place. We don't have it. Guess what? The children are first in line, or one of the first people in line to go, hey, we have 200,000 in assets. That's ours. And so now you're going to get in a different format. So, ultimately we're going to go to the estate to see if there's any other assets that we can allocate the money to the children.
So one would think that that's a pretty simple solution, but let's add another wrench into this whole mess, which is your favorite thing, I think. When you're talking about these situations, it's always fun to like either kill someone off or add someone. And in this case, we're adding a wife. And so the person had remarried and she is going to be in charge of what happens with the money. So she won't give up the money. And the person in question is really only asking for the child support that's due, which was around, let's say $50,000. And the policy was like, let's say around 500,000. And really, she just wants what's owed to her. So, like, where do you go from there? Do the courts care?
It depends. If you care enough, yes, the court will care. So you can file a proof of claim and you can file a lawsuit against the estate. And if you do that, the court's going to say, okay, what's your authority? And you're going to refer back to the separation agreement that says you were supposed to have this policy in place. This is the child support. And ultimately, that is going to control. Now, the reality is, we did this agreement 10 years ago, and the children are older, and the children are only 2 years away from being emancipated versus 15 years being away from emancipated. So you have wiggle room as the recipient to go, yeah, you know what, I don't need the full 200,000. I'm only going to take a smaller amount because I only have 3 years left on child support. But that's at your discretion because the document is still a binding contract, and it's a binding contract on the decedent, which then becomes a binding contract on the decedent's estate.
So what do you do then? You sue somebody and you have the proof, and that person just isn't going to let you have that money because it's now coming out of their pocket. or the estate's pocket, I guess, that they thought they were going to get. And what are they like? They had no idea. Maybe they didn't know because they weren't going through the divorce back then, and they have not children of their own and didn't go through their own divorce, and maybe they just don't know. But like, is not knowing enough to just keep the money?
No, it's not your money, it's the decedent's money. So sad for you. We don't care. Um, the decedent has an obligation, and just like any other obligations, just like a credit card company, if they want to sue after the person has passed away, they have the right to do that. We have the obligation as the personal representative to negotiate that. But there are things that we have to pay. There are things that we don't have to pay. That's like saying, well, there's a mass health lien. I don't want to pay it. Well, great, good for you. You don't get to make that decision. The law makes that decision. So you would have to defend it in court. You'd have to argue it. And you'd have to either come up with a settlement number or ultimately you have to pay it. And it's not you paying it, it's the decedent's estate paying it. So, no, let's be clear about this is that if it is a spouse, it's not coming out of the spouse's money, it's coming out of the decedent's money. So if everything was a joint bank account, then that automatically goes to the surviving spouse, and that's not an asset that the decedent had upon death. So what we're talking about is the decedent had a bank account, he had a 401k, he had other assets that were solely in his name that weren't joint with his spouse, and those become assets of which you can collect on.
And if this has been a little while and the decedent's wife spent all that money that maybe came to her because that was in the will and nobody really thought about this. I mean, do they think about it? Do they go through and say, "Hey, you owe this, life insurance policy that like do I don't think that they do."
Well, it all depends. Let's start with, was the estate probated? If the estate was probated, then everyone should have gotten notice. And even if you didn't get actual notice, it was published in the newspaper. Sorry, if you didn't read it, you didn't object in time, you didn't file your proof of claim, you might be out of luck. But if you did see it and you did do the right thing and you did file the lawsuit, then yeah, you're entitled to it. So it is about timing. So we're going to look at when the decedent died, when that estate was probated, and obviously you have a limited time in which to file a lawsuit, and that is 1 year. So no, you can't do it and go, well, it's been 5, 6, 7 years and I'm looking for some money now. Not in Massachusetts, you're not. Because after 1 year, we have no obligation to pay. So again, it's all about timing and about knowledge.
So playing dumb does not work in effect.
It does not. And playing dumb will get you nowhere. And on the other side of that, the reality is if you're the spouse and you go, well, we don't have to worry about it because there are no assets, you're actually potentially have liability too, because if you don't probate the estate, the clock's not starting. So, somebody else, Jane Smith, can go, oh, I'm a creditor, I'm going to file, and I'm going to be PR, and then take you out of the loop. So it's really in your best interest that when it happens, everyone does the right thing timely.
So when you say, let's just define the probate again. So a process happens, somebody dies, there's a will, but then talk about the probate.
So arguably, upon the decedent dying, the estate should be probated within 30 days. So we should be able to locate the will in that period of time, file the probate. If there's a will, we want to look at, do they have real estate? Are people going to contest it? Are all the heirs and all of the beneficiaries going to sign off? If not, then you're going to have to file a formal probate. If they are, then you might be able to get away with an informal probate. If we have real estate and we want to sell that real estate, then your best bet is probably do a formal. So you have a lot of different options as to what you're going to file. And you certainly want to talk to an attorney about what that best option is. But we file a probate. After we file the probate, they're going to ask you to publish it and to notify all the heirs and get their assents, or they have a right to object. And that publication is going to have an objection date as well. And then once that objection date expires, if nobody has objected, then the person that is requesting to be appointed will most likely be appointed. Now, if your request happens to be different than what the will says, you're going to have to articulate why you should be first in line. And sometimes the court will either have a hearing on it, or they may deny it altogether, depending on what's going on. And then once you're appointed, you have an obligation to represent that estate in a fiduciary capacity and basically walk that through for the next year and pay off creditors accordingly.
So anyone can go up and say that they'd like to handle the probate and go through all of the bills and pay them and be first in line to do that. And what if you said a creditor can also do that?
Yeah, I can't say it's just anybody. You have to have some kind of relationship. Jane Smith off the street isn't going to say, I'm going to probate this person's estate, but I don't even know where they live because I don't know where they live. So obviously you don't have the information. But it's going to be a creditor. It's going to be a family member. Maybe it's not the spouse. Maybe it's an aunt or uncle. Maybe it's a child. So again, depending on who it is, those people would come out of the woodwork and say, I want to be the personal representative. Again, we're going to look at, is there a will and what does the will say? Because if the will designates a person, we're going to use that. But maybe that person says, I absolutely don't want to do it. Then we're going to have to get their renunciation. And we're going to have to go to the next person in line. But if there isn't a next person in line, or that person has passed away, then obviously we're going to figure it out and we're going to ask the court to appoint somebody, and maybe that is me because I'm the one that filed the petition. So again, it all depends on the circumstances and that particular family.
So that's interesting. So I guess step one is to figure out if they did in fact probate it. Are there cases where the probate just doesn't happen?
There are, and those are the cases that become a little more frustrating because what ends up happening is they didn't probate. It was a husband and wife. They didn't probate it. Husband left everything to the wife. Why are we all caring? Nobody cares. I don't need to probate it because it's just my husband. But then wife dies and she has a will, and the sellers want to buy this property, or the buyers want to buy this property, but they can't buy it because we haven't probated husband's estate, and then we have to probate wife's estate, and so then becomes an issue with title. So that's usually where it comes into play, is people don't do it because everything's left to me. I don't need to. Great. But at some point, we're going to need to have these steps in place. So sometimes they do wait and don't take action. Again, I think you should always consult with an attorney to find out really if you need to probate an estate or if you can just file a voluntary statement, or you don't need to do everything because maybe it's all in trust. So it really depends on the circumstances of the parties.
Wow. This is quite a web. So I suppose that there's still a chance then if they didn't probate it, then the clock starts from whenever they probate it, right?
Yes and no. There is a clock that basically starts from the date of death and says if you're doing it for more than 3 years after it, you better have a really, really good reason why. And really, it's the exception to that, of course, is like people like Mass Health, which apparently they get forever. But, short of them, we have to really state something. And it's usually because, hey, look, we realized that we needed to do this now because this case has been in litigation and we're settling it. And oh my God, we didn't even realize that. And so a lot of that is what happens where we did something, or, we have this money that we didn't know existed because it was in fine mass money or something. So you have these quirky little things that come up, and that you'd have to be able to articulate it. And more importantly, the court would have to allow it after the 3 years.
I mean, so that's interesting. It sounds like you just need to keep track of that. So if you're getting child support and your ex dies, then you should either file for the probate if they didn't, or, let someone know that, things need to happen, because that's That's pretty serious if you aren't able to take care of your children in the way that they should be taken care of because you're missing a huge part of your income on their behalf.
Absolutely. And again, that's timing's everything. I mean, the reality is, I've been in cases where we're negotiating, you know, who's going to pay what in child support and pending cases. And unfortunately, one person passed away is in the middle of it, and you're going, okay, well, I guess we're dismissing this case, and you have to dismiss it, but then you're kind of at wit's end as to, well, now what's the next step? And a lot of my clients are just like, I'm just done, Nicole. And I'm like, but you're leaving money on the table that belongs to your children. So it really depends. But I mean, most people know when their ex passes away. So be timely about it and do something about it.
Now, you brought something else up during this conversation, and it was just like about titles and inheritance and wills. And there's another situation I heard of where the parents weren't great. They had one child, and they both ended up dying within 9 months of each other. They had been broken up. One of them had a will, didn't have much. One of them did not have a will, but had a house, and now everything is tied up, and trying to get the title so that they can sell the house, and it seems like they're fighting an uphill battle.
Yeah, it definitely happens, unfortunately, more often than not. And again, it's about planning, it's about communication, and it's about taking action.
And so if you have parents that are, sickly or elderly, get them to get their documents in order. And they're all the documents that you and I have talked about on several occasions. There's powers of attorney, there's health proxies, there's a will. I mean, there's a lot of things that you can put into place before things go south, and just to have something there just in case. It doesn't I think there are some people that are superstitious, and the second they set up a will they think that they're going to get struck by lightning, but you really do put your kids or people that are inheriting things from you through a lot of extra time and money and aggravation, just trying to figure out everything on your behalf after you're passed.
Absolutely. And again, that's the hardest part is just being able to do that. I always say, great, you can say you have nothing, but just plan for this because you don't know when it's going to happen. Everyone, oh, I'll take care of it later. I'll take care of it later. Well, later, you don't know when later is. And that's the bottom line. So, look at it, update it regularly, pay attention to it, know what your assets are, and more importantly, know who you're leaving it to and who's going to be in charge because, again, that relationship might have deteriorated or, God forbid, that person passed away. And then what happens?
Do you put a second person in charge with the power of attorney? Just in case? I mean, I know when you're doing a will, there's a lot of options. You kill people off, but do you kill off the power of attorney people
I
to
kill
have
off
a
the power of
second and third?
attorney people. I kill off the power of attorney people and I kill off the healthcare proxies because again, you never know what's going to happen. And depending on the ages of the first person and the second person, I might even go to a third person because again, you don't know. I mean, the reality is how many times have people gone on family vacations? Something happens on the family vacation. Great. We just lost a whole team.
Yeah, separate planes. That's why people do it.
That's why people do it. And that's why I won't do it because I'm not dramatic like that. But the
Yeah.
reality is, in my field, I have to come up with those scenarios because I know that the law says, within 30 days. So even though I may survive the plane crash, guess what? I still have to live 31 days for it to matter.
There you go. Are there any parting pieces of advice that you have for us today?
I think it goes back to again, you want to plan because you also don't know when something's going to happen. Maybe it's just that, you all of a sudden come up with an incurable disease or you have, you know, early onset dementia or Alzheimer's and you just can't function. At some point, The problem is if you wait for that diagnosis, you're actually hurting yourself. So you want to make sure that you plan ahead, and maybe you don't have the capacity to change it at some point, but at least you know it's there. It was there to begin with, and at least it's something, because something is better than nothing.
So that's amazing. And thank you so much for your advice. I mean, this is one of those gotchas that a lot of people don't even think about. They just assume that if they have a life insurance policy that's been directed by the court, that it's just obviously going to be there. And the fact is that you should check in on that information from time to time. And how often would you recommend? You have to request through your lawyer, I would assume, but how often would you recommend just checking in to see if the life insurance policy is still in place?
It's always written in a separation agreement that says, upon reasonable request of. So if you have any doubts or if you have any concerns, you should ask. I mean, my answer is always ask at least once a year, because you don't know. Things come up. Life forgot. Oh, I forgot about it. Oh, it's direct deposit. I changed that account. I closed it. I mean, how many times have any of us done that? And then now the policy has lapsed. So ask for the policy on a regular basis, at least yearly. A lot of times you'll have provisions in there that says we're going to review the tax returns every year, every couple of years. When you're doing that, ask for the insurance policies as well, because so long as there's a child support obligation, that obligation continues.
Can you ask for tax returns if it's not like during a court case?
If it's put in the separation agreement, yes, you can.
Well, you need to have a great attorney like Nicole. Uh, if you are going through a divorce or a separation or a breakup, Um, very wise advice. It comes from the Reeves Lavallee law firm in Worcester, and I would highly recommend them. She and her team really have great strategies and can give you, give you the advice that's real. I mean, if it's not good news, she's not afraid to tell you that either.
Yeah, unfortunately, we do have to give out bad news, but I'd rather have you have the bad news than not, be ignorant about it and then not have any choices and not know where to go from there.
And I guess the last question is, what if you had a bad attorney that didn't really handle the case right in the beginning? Then you're kind of out of luck then too. Is that right?
Depends. I mean, obviously, if there's a basis for a modification, and that is one of the issues that we're addressing indirectly or otherwise, we could probably amend that and include that as well. Now, obviously, when you do like a divorce the first time and you say, oh, well, I'm paying for all the child extracurriculars, trying to get that after the fact is really hard. But things like a life insurance policy, the court's going to go, of course. So it really depends on the circumstances.
Well, thank you so much for coming on the show today and giving us this information. I encourage anyone to give your office a call if they do have questions on this and further questions on their own situation. The advice could be completely different depending on what's going on in your case. So thanks again, Nicole, for coming on, and I hope you have a great weekend.
Thanks for having me.
You're welcome. We'll see you soon.